Good afternoon, distinguished guests, faculty, students, and friends. My name is Alejandro Pasquel, Master of Ceremonies. In 4 days, September 17th, we commemorate the 234th anniversary of the United States Constitution. As part of our celebration, it is an honor to welcome Professor Danielle Citron from the University of Virginia School of Law and Ms. Jennifer Huddleston, Director of Technology at the American Action Forum. Professor Citron and Ms. Huddleston are here today to discuss Section 230, the critical question of free speech online. The Society of Constitutional Policy appreciates your time to share your thoughts on the questions. Please allow me to introduce our panelists. Mr. Jack Hennigan, Mr. Kenneth Shaw, and Ms. Sarah Wu. Now, please join me in welcoming our moderator, Mr. Noah Stein.
Thank you, Mr. Pascal. Ladies and gentlemen, as Mr. Pascal stated, on Friday, September 17th, 2021, we celebrate the 234th anniversary of the signing of the US Constitution in 1787. 4 years later, Congress amended the Constitution by adding the Bill of Rights, guaranteeing certain liberties to the people and to the states. Today, with the help of our guest speakers, we will examine a current issue rooted in the First Amendment, free speech online. The First Amendment proclaims that the Congress shall make no law abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. Thus, the First Amendment protects the freedom of expression. 25 years ago, Congress passed Section 230 of the Communications Decency Act. Section 230 ensures that online platforms will not be treated as publishers of the content of third parties. It states, no provider or user of an interactive computer service shall be treated as the publisher. Traditionally, a publisher must moderate the content within their publication. But on the large scale of the internet, websites do not have the same means to do so. For instance, users of the popular video sharing platform, YouTube, upload more than 500 hours of video every minute. They simply lack the capability to moderate all of this content. Because big tech websites are not considered the publishers under Section 230, they can host controversial content without the fear of legal action for what their users post. Thus, Section 230 is interpreted as providing immunity to online platforms for the content posted by their users, and Section 230 therefore allows free speech to flourish online. However, not everyone believes that Section 230 encourages free speech. Politicians have criticized Section 230 for allegedly being partial when evaluating online content. One notable example of such criticism arises from former President Donald Trump's executive order claiming that Section 230 leads online platforms to practice selective censorship, believing that these platforms silence conservative voices. This incident, among others, raises serious concerns. Can Section 230 be amended or replaced without violating the free speech clause? How can we best promote free expression online? This afternoon, we will address these issues. Professor Citron and Ms. Huddleston will each have 10 minutes for opening statements. Professor Citron, the floor is yours.
I'm pleased to be part of this conversation about Section 230. So when I first started writing about the Communications Decency Act, and I'll underscore that in a second and explain why, in 2008, I called for an amendment to Section 230, which I'm going to talk about. But at the time, the idea that we would touch Section 230 and its essential license or subsidy of online platforms for under or over filtering speech was heretical. And what's fascinating is here we are, talking 12 or 13 years later. And the notion that we might change Section 230 is not only not insane, but is part of the popular conversation that we are having. It's of a moment, Section 230. So I'm just going to start by explaining the subtitle of the part of the statute that we're focusing on. It's Good Samaritan Filtering and Blocking of Offensive Speech. That's the title of Section 230 of the Decency Act. Now, the Communications Decency Act was essentially an anti-porn provision. It was chock full of criminal laws that would essentially make it illegal to facilitate and publish pornography, which is, the statute itself was largely unconstitutional, and it was struck down on First Amendment grounds as both overbroad and so in the wreckage, though, most of the Decency Act is struck down by the Supreme Court in ACLU versus Reno. But what remained was Section 230, the Good Samaritan filtering and blocking of offensive content. Now, it does two things, essential things, right? Mr. Stein mentioned the first provision, which provides a legal shield from liability for the publication or speaking of somebody else's content, information provided by another interactive computer, another provider. So user-generated content, right? But there's another provision, one that is actually also in hot debate, which is it provides a legal shield for taking down too much speech, so long as you do it in good faith. Now, you might say that provision, Section 230C2, in some respects, there is some protection around taking down too much speech, and that is, it's conditioned on doing so in good faith. But in truth, what are you going to sue when someone takes down your speech? What's the cause of action, right, against a provider from taking down your speech? It's hard to come up with one, right? And in many respects, there's no question that sites would assert their own First Amendment protections. They're private companies. And they would say, if forced to host speech, they don't want to speech. They would say, you're coercing me, you're compelling me to speak. So it's unclear if even the complaint that sites are filtering and blocking too much speech, if we were to tinker with anything with regard to 230C2, if we could actually do so in a way that's consistent with our commitment to the First Amendment and the fact that we're dealing with private companies that are filtering speech, right? Okay. But the empirical claim in the executive order issued during the Trump administration that conservative voices are being silenced is empirically, let's just say, unproven. It's unclear if that's in fact the case, but there is a real problem with Section 230, and that has to do with the first provision, the legal shield for doing too little, for under-filtering speech that's harmful and that silences speech. So there are sites whose raison d'etre is abuse, right? Revenge porn sites, deepfake sex videos, sites whose entire the principal purpose is to host harmful behavior that is illegal. Those sites get to revel in Section 230 and say, I'm not responsible for that speech, right? Sue me. I get to move to dismiss it. It's immediately going to be, there's no question, I'm going to enjoy the legal shield. And that's true of sites like thedirty.com. There have been cases where true scofflaws, right? Sites that their entire purpose is to facilitate and enable crimes and torts, they get to enjoy immunity from responsibility. But also Section 230, so you might say, okay, Danielle, why don't we just say for those scofflaw sites that we should remove them from the legal shield? We remove from the legal shield, it's not a free-for-all Section 230, federal criminal law, the Electronic Communications Privacy Act, and intellectual property law is also, as well as the knowing enablement or facilitation of sex trafficking, are also taken out of the statute. I'm not thrilled with Boston Cesta. Later we can talk about why. But it's not a legal shield for everything. So you might say, why don't we have a sort of narrowly scoped carve out, right, for scofflaw sites. And in my book, Hate Crimes in Cyberspace, I sort of propose that we have a sort of another narrow exemption for sites that engage and principally host non-consensual pornography and cyberstalking. But the truth of the matter is, I think that's not ambitious enough. We have, unfortunately, it's not just the scofflaws that are the problem. The fact that we have providers that facilitate harmful, illegal, criminal activity, even though that's not their principal purpose, but make money from the collection of data and the hosting of such data, they get to basically, they don't have to spend that much money, right, on dealing with hard problems, and they should have to. So I have to say, Mr. Stein, when you introduced the panel and you said, woe is YouTube, they can't possibly pay for the moderation of speech. I'm not woe is Google anything, right? This is a company whose capitalization is astounding, right? The amount of money that they have. And if you're going to host speech that enables crimes and torts and host gun sales and whatever else, you should be responsible, right? And so my proposal is not that we take away Section 230, but instead that we should condition the legal shield in Section 230C1 on reasonable content moderation practices in the face of clear illegality that causes serious harm. Now, so what that would mean is you have to earn the legal shield. And again, let's go back to what Cox and White wanted when they drafted the statute, which was for Good Samaritans, right, filtering and blocking offensive speech. Let us give that immunity to the Good Samaritans. That is, those engaged in reasonable content moderation practices in the face of clear illegality causing harm, right? If you don't deserve that, right? If the idea of Section 230, which is the principal purpose, according to Congressman Ron Wyden and Chris Cox, was to incentivize self-monitoring, to act as Good Samaritans, well, then I believe we should fulfill that purpose, right? And condition it on reasonable content moderation practices. And I'll end there.
Thank you. And now, Ms. Huddleston, if you'd like to give your opening statement.
Thank you. And thank you for setting up this excellent debate on what is certainly a very timely topic. And to Professor Citron's comment, I have not been working in this area quite as long as she has, but even the change in the debate from this being a very niche issue when I started working on it about 5 years ago to something that now it feels like anytime you turn on the TV or talk to anyone that they at least think they know what Section 230 is all about. We can debate some of the great myths out there about what Section 230 is and does. As was previously mentioned, it is important to understand what Section 230 is and does, as well as what it doesn't do. That it enables platforms to engage in content moderation and in fact encourages them to engage in content moderation. That it does have exceptions for a lot of federal criminal laws, and that some of the debates over potential additional carve-outs may actually be debates about the underlying criminal law rather than Section 230 itself. And then finally, I think it's really important to note that Section 230 has this element of personal responsibility to it. It says that if someone does something bad online to you, that they are the person you should go after, not the platform that enabled it to be posted or that the platform on which it was posted. Now, when we're talking about Section 230 and the debate over online speech, I think there are a couple of other ground rules that are often important to have this broader debate. The first is that the debate over online speech shouldn't be about defending particular companies. This shouldn't be a debate about Facebook's own personal content moderation policies or YouTube's content moderation policies or Twitter's or TikTok's. Almost all of us in this room probably has seen some decision made about user-generated content on one of the platforms we use that we think if I was the person in control, I would have made a different decision. What this debate is really about is who should be the one to decide how those decisions get made. Should it be the platforms and then the response of users in the market about whether or not to use those platforms? Or should there be further policy interventions that dictate which of those decisions are and aren't allowed to be made? And secondly, I think it should be noted that those of us who tend to defend Section 230 or think that Section 230 serves a particularly important role in enabling online speech are not pretending that utopia exists, that the internet doesn't have bad places. Rather, it's important to recognize that technology is a tool, and that when we're looking at those bad things online, we should be looking at addressing the underlying problems, not at the existence of the technology. So there are some things that Section 230 does really well. It has enabled the growth and flourishing of speech online by encouraging platforms to host user-generated content, or at least lessening their fear that choosing to host other people's speech could result in industry-ending liability. Now, this isn't always, I argue that in some of my research, that this isn't always the strange anomaly that it gets portrayed as, that if you look back at the legal history around other intermediary liability laws, if you look at how the courts interpreted laws concerning libraries and the books that they carry, or how they've interpreted laws regarding wire service news stories and newspapers and on radio stations, there's actually some more traditional media analogies that would result in something that, while not necessarily exactly like Section 230, is rather similar. Second, Section 230 is critical both to large platforms, but particularly to small platforms. We talk a lot about Section 230 in the context of Google or Facebook or YouTube, platforms that have to deal with the problem of the sheer amount of content they have that can make it very difficult, even when they do have good and reasonable content moderation practices, that mistakes happen just from sheer volume, or because content moderation often requires context-specific decisions, they may miss something as they're trying to update their systems. But Section 230 is incredibly important to enabling small platforms to enter the market and carry user-generated content. Those platforms who may not have full-blown legal teams available to them. And this includes not only platforms in the social media space, but a lot of different types of platforms that are carrying user-generated content. Things like Yelp for reviews, or the comment section on a blog post, or even a traditional newspaper are all protected by Section 230. Section 230 also allows these platforms to decide the right risk balance when it comes to what's called the moderator's dilemma. So in a world without Section 230, most platforms would be faced with one of two choices. Either you post the no lifeguard on duty, swim at your own risk sign, enter, and beware of what you may see, where you allow all sorts of content and no moderation at all, which makes the internet a place most of us wouldn't want to go. Or you tap down so tightly that you stifle a lot of important speech. You take down anything that might be questionable out of an overabundance of caution that you might end up with liability for that. The other advantage of Section 230 is that it also applies not only to general platforms, but to platforms that may be trying to serve narrow audiences and therefore need a more specific set of content moderation rules. Now, I know that there's a lot of debate about different places on the internet, and there's probably some of those that are concerning that many of us don't think are providing positive impacts on our discourse. But Section 230 is also critical to a lot of voices that were previously unheard in a more traditional media era, whether those are women's voices or minority voices or other voices where the barriers to entry of having to go through a traditional editorial board at a newspaper to get your idea out there were much more unlikely to succeed, where you had to have connections, where you had to have startup capital. Now it is much easier for someone with an idea to create a Twitter account, to create a blog, or to even create their own social media platform or community to serve their own needs. Now, there are a couple of concerns that often get brought up in Section 230 debate, and some of these are concerns that Professor Citron mentioned, but others are just questions that usually get brought up in general. The first one is Section 230 was never about neutrality. In fact, Section 230 is designed in such a way that a platform can choose to be a conservative platform, or can choose to be a liberal platform, or can choose to be a platform where only cat pictures get posted. The second question, though, comes to this issue of, is there a need for additional carve-outs? Are there things that we can agree are harmful where we want to have a higher standard involved? And one of the real difficulties with this is how quickly we get into gray areas where we don't all agree on what qualifies as that thing that we all generally agree is bad. So two good examples of this that have gotten a lot of attention in the last couple of years are misinformation. Misinformation, many of us are very concerned about what it could do to the discourse around various scientific ideas or the discourse around politics. But it's often difficult for the same two people to agree on what exactly constitutes misinformation versus what constitutes debate. Another great example of this is bullying. Everyone agrees online bullying is bad and is a problem, particularly among young people. But again, looking at language and clearly identifying in a way that all platforms can moderate at scale what is and isn't bullying becomes much more difficult. And if we look at things like the DMCA, which governs copyright and intellectual property as an alternative system, we also see how quickly and costly this gets and how likely platforms are to respond by removing speech rather than allowing continual discourse to flourish. And as I mentioned, there's also this concern about how Section 230 changes would potentially impact platforms beyond social media. Finally, I just want to conclude by distinguishing between free speech and First Amendment concerns and Section 230 concerns. Oftentimes we hear calls about how big tech is censoring a certain viewpoint or certain types of voices. But this is really a misuse of the word censorship. And it's very sad and concerning when we're still in a world where in other countries, censorship by the government that prevents legitimate discussion of speech is still rampant. At the same time, many people who are crying censorship or arguing that we need Section 230 to change because of a desire to promote free speech or prevent private actors' censorship are making proposals that would call into question the government's intervention into the decisions by private actors and themselves raise free speech and First Amendment concerns.
Thank you both. We will now proceed with questions from our panelists. Professor Citron and Ms. Huddleston, you have 5 minutes to address the question, then 3 minutes to respond to the other speaker's point, and finally, 2 minutes to defend your original point. Mr. Hannigan?
Thank you. Professor Citron, in your book, Hate Crimes in Cyberspace, you maintain that companies should be subject to the technological due process, which is tailored towards the internet. Please explain this concept, technological due process.
So what I mean by technological due process in the context of speech policies and practices is commitments. So due process is a concept that applies to the government. That is, when you're going to take away someone's life, liberty, and property, you owe them some sort of accountability and transparency, right? So it's, of course, I'm borrowing the concept of due process, having some kind of fair hearing before something you're interested in is taken away from you. I'm borrowing the concept of accountability and transparency and saying, in the context of content moderation, so speech policies and practices by private parties, they're not state actors. But we can, at a threshold matter, say that for no matter the platform, right, no matter at the content layer, no matter the party, the entity, that they have to be clear about what their rules of the road are. So transparency, right? So clear about what they mean if they're going to ban hate speech, clear what they mean by that concept with examples, right? Providing some fair warning about what their policies and practices are, which is this idea of in due process of fair warning, and that they have mechanisms of accountability. that if speech is going to be taken down or content is going to be taken down or de-emphasized, right? All the different ways that we can algorithmically sort of highlight or de-emphasize or take away, filter, block speech, that we need an explanation, right? So if your speech is going to be, let's say, filtered, blocked, or de-emphasized, then companies need to provide mechanisms of accountability, explain what they've done and why, and a chance to object. So that's the concept of due process, one that I explored in an article called Technological Due Process, which is about automated decision-making, right? And the kinds of commitments when the state takes away, for example, your public benefits or puts you on a no-fly list, that you've got to know what's happening to you, why, and a chance to respond and to object. We can borrow that concept in the content moderation practices. And it's the kind of thing that most people agree on, right? That if these platforms are going to have policies, let us know what they are, be clear about what they mean, tell us why, right? They're banning certain kinds of speech, and provide modes of accountability so we don't feel helpless. So that's the concept of technological due process that I think lots of people agree about. This is like the least contested thing I've ever said, I think, in terms of content moderation.
Thank you. And then Ms. Huddleston, would you like to respond to that or with your own opinion on the matter?
So my response is, I agree with Danielle that these are a lot of great principles of we ideally want companies to be transparent. We ideally want there to be a system for appeal. What that looks like in the case of any particular company is going to be very different, as the audience is going to be different. The nature of the service is going to be different. The type of content moderation engaged in is going to be different. I think one distinction I always like to make in these conversations is there's a difference between what we believe should be best practices and that companies should be encouraged to do, and what we believe should be legal policy requirements. So transparency, for example, I think is a great example of a best practice. There may be some ways to make it a legal requirement depending on what that looked like in a way that doesn't raise questions of any kind of compelled speech or revealing trade secrets or other concerns that often come up in these debates. And then there's often that question of, if you make it a legal requirement, well, what happens if a policy changes and the transparency element didn't get updated, or those kind of questions. So I think that oftentimes in this debate over what ideal content moderation would look like, we have to distinguish between what the ideal in terms of best practices are and what the legal requirements should be.
Thank you. And then Professor Citron, if you'd like to respond.
Sure, but I think that's precisely why I would urge us to adopt a reasonableness standard, because what's reasonable for a huge company is really different from what's reasonable for a tiny startup with 5 commenters, right? And reasonableness would do different things, but reasonable content moderation practices in the face of clear illegality would probably mean and include transparency, right, vis-a-vis illegality, and some modes of accountability, and a reasonableness rather than, so best practices is another, I think, a potential way of talking about reasonable content moderation practices, which could be and can be legally required.
Thank you very much. Now, Mr. Shaw.
Thank you. Ms. Huddleston, in your articles, you assert that technology companies under the First Amendment have a right to decide of the content that they allow on their platforms. What protections are afforded by Section 230, but not by the First Amendment?
I think a lot of this goes to how Section 230 fits into kind of the legal ecosystem that often accompanies content moderation decision. I would argue that between First Amendment protections and the existing law around intermediary liability, that in many cases, platforms would still win on their decisions around content moderation if they were sued and had to go through the court system. But what Section 230 does is it provides a legal certainty and prevents the potential for courts to get it wrong. In fact, Section 230 grew out of two divergent court rulings around content moderation, one of which said that platforms who didn't engage in moderation wouldn't be held liable for their content, and the other that said by engaging in moderation, you opened yourself up to liability. Now, it's possible that that second case could have been an anomaly, and we would have seen courts eventually get to something that looks like Section 230 and provide that certainty under the First Amendment. But in the meantime, we would have seen companies have a lot more concerns about the potential litigation. You probably would have seen decreased investment in some of the early internet companies that were carrying user-generated content. And you might have seen a focus on other ideas instead at the detriment of speech being developed. Today, where Section 230 is particularly critical is in the case of those smaller platforms who have the legal certainty that if they do find themselves subject to a lawsuit, that even if they would later win on First Amendment grounds, they don't have to go all the way through the trial period, but instead can defeat that case much earlier when it's much less costly.
Thank you. And now, Professor Citron, if you'd like to respond.
So I think it's important to note, so I want to try to get at Ken's question and then build on Jennifer's comments, which is in the cases that sort of gave rise to Section 230, they were two defamation cases. Where on the one hand, a court found that we're not going to treat you as a distributor unless you of defamation, unless you know or should know about defamatory content, right? Which is distributor liability under the defamation common law rules. And the other was a trial court in New York finding that if you tried to act like an editor, then we're going to treat you as a publisher and therefore strictly liable for defamation. Now, in any given lawsuit, we're not always talking about defamation. And it's important to recognize that when a party is sued, it depends on the cause of action, right? And so platforms, let's imagine we take away 230. I don't want to take it away, but let's say we did, right? If we took it away, platforms wouldn't be strictly liable for content. A party would have to prove the elements of the cause of action, which wouldn't necessarily be about being a distributor or a publisher. Not every case is about defamation, right? And the First Amendment would provide protections, right? As it does for defamation. If it's a matter of public interest, we have to prove actual malice. So I think it's important for us to recognize that Section 230 operates in a universe if without Section 230, we have First Amendment protections, right? So newspapers publish, let's say, a story, right? And they've got First Amendment protections for defamation against defamation under New York Times versus Sullivan, which would protect them unless they published with actual malice, right? Knowing or with reckless disregard to the truth, then they can't just publish everything, right? Like the New York Times just can't be reckless about falsehoods or knowingly publish false information, right? Why is it that an online platform is going to be treated so differently, let's say, small or large, from if the same kind of speech that's as destructive as speech that's in a printed magazine? Why are we going to treat it so differently if it's on or offline? And one thing I just want to make sure we underscore is that Section 230 is not necessarily a win for free speech. I think we disregard the fact that so many women and minorities' voices are silenced due to Section 230 because people who are under online assault, stalking, harassment, threats, right, stuff I write about, intimate privacy invasions, they go offline. Right. And so we can't say just without question, Section 230 is a win for free speech. I know as an empirical matter, that's not necessarily true. We don't really know the full breadth of the harm, but we do know the breadth of the harm of cyberstalking.
Thank you very much. Ms. Huddleston, if you'd like to defend your original point.
Well, again, I think Danielle and I agree that in many cases, particularly the type that gave rise to Section 230, as well as often the type that are in the news today when we're talking about calls over banning former President Trump or calls around certain type of content being taken down, the actual outcome would be very similar to what we see now in terms of the way the First Amendment would interact. And I actually agree that we often are talking about Section 230 in the context of defamation when there is a wide range of actions that can come up when it comes to Section 230. But I would still point to the importance, not just to large platforms who are dealing with this at scale, but to those smaller platforms who may be trying to come up with their own reasonable moderation standards and make honest mistakes along the way and have the benefits of Section 230 and helping to develop those standards.
Thank you very much. Now, Ms. Wu, for your first question.
Thank you, Mr. Stein. Professor Citron, do you think Section 230 has become a free pass for internet companies to avoid their responsibility of regulating illegal content, such as identity theft and stalking?
So I have a somewhat complicated answer. It is, just as a matter of market incentives, a free pass, right? That is, legal incentives. Like, we've taken away the legal reason to be proactive about stalking, threats, right? Other kinds of abuse that's often targeted on women and minorities. And the response to me is always, well, that's not really true. Yes, legally it's a free pass, but there are market incentives. And my response is, okay, the market's been operating, right, for 25 plus years, and we see a lot of harm. Now, it's true that some companies will, because it's in their interest, deal proactively, like with something with let's just take non-consensual pornography. Facebook has been pretty proactive about staying ahead of the curve and sort of adopting the newest technologies to address non-consensual pornography. Why? It's not because they care about women, though I've advised them for a long time without pay. It's because it's in their interest. They ban all nudity, right? So consensual, non-consensual, they don't care. They want it out, right? And so it's not that the market is so much pushing them. It's just, it's their agenda, but it's not like some reputational harm that's external to them is pushing them in that direction. Now, let's just take Facebook on the other hand for non-consensual pornography. They have policies against it. They have since 2014. But I can't tell you the number of times that victims come to me and ask me to get in touch with people that I know at head of safety to take content down, that at scale, they just are like, sorry, too bad, so sad. So people are tormented by their nude images posted on sites that have a policy against non-consensual pornography, but don't do a good enough job. And so I think that it has in many respects been a free pass. I don't want to say that it's like a free-for-all and we've seen so much harm, but that is that they're not doing anything. But it allows them to rest on their laurels and not put their money where their mouth is, really, because there's no legal task to say you're not acting reasonably. So in that respect, I think we need law to evolve, to develop, and to bring some sense of accountability into the space.
Thank you. And Ms. Huddleston, if you'd like to respond.
Sure. I do think it is important to acknowledge that there is a lot of harmful content that falls through the cracks, and more than any of us think there should be. And hopefully companies are continuing to improve their AI tools, their content moderation tools, to be able to identify this and take it down more proactively and sooner, with less harm to occur. I probably disagree with Professor Citron a little bit about the response to market incentives. I do think that the market incentives, because most platforms don't want to be the place that's filled with porn. Most platforms don't want to be the place that's known for hateful speech. There unfortunately are some platforms that are okay with that, but most of your general use platforms don't want to be associated with that kind of content. And as a result, they've taken proactive steps. Additionally, there are some interesting questions about how the role of advertisers on platforms is also asserting market pressure around certain issues to potentially have content moderation policies change. There's debates about whether that's a positive or negative market force as opposed to the users. But again, companies are often responsive to these questions that may hit their user base or may hit their bottom line. I think the other thing to point out about Section 230 is Section 230 does not prevent you from going after the person who actually posted the content. So the person who shared the non-consensual pornography can still be sued without Section 230 protection. Now, there are some questions about how this gets handled in a world where there is anonymous speech. And there are certainly a lot of reasons historically why we don't want to say just do away with anonymity that we can get into if time allows. But I do think that's a critical point in these debates about what to do with the harm that comes from this content, is that Section 230 says you can't sue the platform in many of these cases. It doesn't say you cannot sue the user who posted it.
Thank you. And then Professor Citron, if you'd like to conclude on that question.
Okay, super quickly. First point about market incentives, I'm going to channel FTC Commissioner Rohit Chopra and saying that the market incentive is because this is an advertising driven space, right, at the content layer. The incentives are to optimize for engagement. And what sells is sex and gossip and salaciousness. That sells, disinformation, strong feelings. And so I think the market is pointed in our to the lowest common denominator, which is non-consensual pornography, disinformation, pretty harmful stuff. Okay, that's the first point. The second is that the suggestion that we can sue the poster, having worked so long in this space. I'm the vice president of the Cyber Civil Rights Initiative. I can tell you that having talked and written about victims for so long, that you can't find the poster. If you find them, there's no deep pocket. So suing them is just it's not possible. Why sue them you're going to get no money, right? And no lawyer is going to take your case unless there's a deep pocket to sue. And the second is law enforcement dismisses you. So the idea that in theory, we can go after the poster, in practice, it's untenable.
Thank you both. Before we move on to our panel's second questions, I'd just like to remind the audience that they are welcome to submit a question through the chat function on the live stream, and it might be read out loud if time permits. But without anything else to do, I'd like to welcome Mr. Hennigan back for his second question.
Thank you. Ms. Huddleston, Justice Clarence Thomas compared big tech companies to common carriers and public accommodations. Do you agree with Justice Thomas?
So this has become the latest challenge in the Section 230 debate is are social media platforms, particularly large platforms like Google and Facebook, so large that they need to be reclassified as common carriers? I would argue no, for a couple of reasons. First off, this is still a very dynamic market and it's still a very competitive market. You are free to go from platform to platform. There are new platforms constantly emerging. There certainly are a lot of debates over TikTok right now, but TikTok has been a market disruptor in the social media industry very, very quickly, particularly with Gen Z. So the idea that what we normally see with common carriers is some sort of natural lock-in with very high costs where you cannot switch easily and where there's not really an alternative to go to if they cut you off. Additionally, with this common carrier debate and social media, we also have to think about the fact that the internet and speech are much larger than just social media. There are a lot of other ways, particularly in the context that this argument often comes up, which is usually in the discussion around public officials, they often have many more elements at their disposal that they could address the public in such cases. Now, that's not to say that social media and online speech haven't been incredibly valuable to the average users, but we aren't seeing the kind of typical actions that we would see associated with a kind of potential common carrier dynamic. The other thing I think is really interesting about this debate is how it relates to the net neutrality debate. The net neutrality debate was a debate over whether ISPs could block or throttle certain content. There were a lot of other elements at play with it, but that's kind of the short version of it. And what's been really interesting to see is that many people who were against net neutrality are now, or some of those same scholars that were leading critics of net neutrality are now proposing common carrier style regulation for social media platforms. We could have a whole nother debate about net neutrality and speech and how that could play out. But the dynamics at play here don't necessarily reflect the reality of, if you believe that private actors in the ISP market should be able to decide whether or not they want to block or throttle content, or at least be allowed to have that decision, but you don't believe that edge providers, which is the term for kind of social media platforms, websites, et cetera, should be allowed to have that. That's a very difficult distinction to try and make, particularly given the diversity of the market. So the short answer to the question is no, I don't believe that today's social media platforms are common carriers.
Thank you. And now, Professor Citron, if you'd like to respond.
Well, we're definitely in heated agreement here on this one. I think the idea that we're going to treat, of course, the question is the metaphor that we use. We have metaphors and analogies that we can use to think about different players in the stack as we think about sort of the different players that give us the internet that we have. And none of the analogies are fabulous. Like there's some things, right, like mix and mash a little bit, but definitely common carriers. I think that just as a practical matter, the notion that you have to carry everything, much in the way that we think of the Postal Service or ISPs or broadband, whatever that debate is, like the notion you have to carry content is like an internet I don't want any part of. So I'm just going to agree with Ms. Huddleston here.
Thank you. And then Ms. Huddleston, since you both agree, you still have the 2 minutes if you'd like to defend your original point, but only if you'd like to use those minutes.
I mean, the only thing I will add to the original point is in discussing this idea, I think it's really important to consider what the consequences of classifying these platforms as common carriers would be and what that might mean for innovation. Oftentimes people proposing this are mad at today's large platforms, but regulating them as common carriers could actually lock in today's giants much more than encourage more diversity.
Thank you. Now, Mr. Shaw, for your second question.
Thank you. Professor Citron, you maintain that Section 230 serves as a shield of liability for the over or under filtering of offensive content. In your view, which is worse?
So it's not that neither are bad, right? The over, that is precisely what Cox and Wyden, in some sense, wanted, that we filter, we block, we don't. It's the moderator's decision, right? And it's true that, so I guess really your question is, assuming that we want them to engage in moderation, where's the problem, right? Is it that we're taking down too much or that we're taking down too little? And I'm decidedly in the camp of we're taking down too little, right? It's unclear to me that we're taking down too much. I think it's hard for us to figure out how you would sue if you're taking down too much. But I do know that the empirical evidence does not suggest, at least it's unclear, if indeed we're seeing censorship of what many have said, like I'm thinking of Senator Cruz, Senator Hawley, that we've seen an over censorship of conservative speech. It's just not clear if that's true. right? But where we see real harm, right? So I don't think like I'm worried about Hawley and Cruz's having an outlet to speak, because I'm going to go back to Ms. Huddleston's wonderful point about we have diversity of outlets, right? But where the real problem is, right? So if you're kicked off one platform, you likely can go to another, right? On the other hand, when you keep up speech that's incredibly harmful, speech that threatens, that invades intimate privacy, speech that is effectively cyberstalking, you chase people offline. You ruin their lives, their careers, and their life opportunities. And so I guess the problem is indeed, right, one of under filtering, not over filtering, though Cox and Wyden contemplated a little bit of both, right, if you're acting as good Samaritans. And I just want them to act as good Samaritans.
Thank you. Now, Ms. Huddleston, if you'd like to respond.
Sure. So to this kind of question about over filtering, I think it's often easy to find a single anecdote and try and extrapolate out from that something that's a much broader trend. There's certainly, as I kind of said in the beginning, this discussion shouldn't be about defending any particular platform's decision on any particular piece of content. There certainly are decisions that we all disagree with, regardless of what side of the aisle you're on, that you think they shouldn't have taken, that they didn't take something down fast enough, or that they took too much of something down and that it should have been left up. So I think that's important to note. I also want to speak just briefly to this claims of anti-conservative bias online and point out that the rise of online speech has actually been great for conservatives. Conservatives were one of those groups that oftentimes had a hard time getting their voice heard in the quote unquote mainstream media. But now they can go to the Federalist, they can go to Town Hall, they can go to Twitter, they can go to YouTube and build a brand and a following. And candidates no longer have that barrier of needing their local paper to give them space or needing airtime on local TV to get their voice out there. I will say, I think it's hard for me to say over or under filtering, because I think so much of it depends on the particular platform, and so much of it depends on our own awareness of different types of content. We've seen this in debates over different things during the COVID-19 pandemic, where the science was evolving in real time. And it was often hard for platforms to keep track of what was legitimate disinformation that they wanted to ensure wasn't getting out there, and what was part of the changing scientific debate. So while there are some things that we can all look at and say, yes, that's bad, take it down immediately, I think that's often a much smaller box than we instinctually think it is, because we all tend to presume that everyone thinks the same things are on the same side of that gray area as we do.
Thank you. And then Professor Citron, if you'd like another 2 minutes just to defend your original point or give any further information.
I do think it's worth underscoring that I guess my refusal to be, I'm not agnostic about the problem, because there are over 9,500 sites whose sort of focus is intimate privacy invasions, right? They peddle non-consensual pornography, hidden cams, deep fake sex videos, and the costs are really high. They're really high for more often women of color, lesbian, trans women, and more broadly, sexual and gender minorities. So there are real costs. It's not, so the 9,500 sites, think about it, right? There are thousands of pages on each of these sites, and the consequences for those individuals are really grave. And so we can't just ignore that cost, or we shouldn't, right? And so I'd like us to bring it to the fore to recognize that those sites persist, that they cost people their lives and jobs and careers and their loved ones. And it's a cost we should deal with.
Thank you very much. And now we'll move to Ms. Wu's second question.
Thank you, Mr. Stein. Ms. Huddleston, does Section 230 specify the difference between a platform and a publisher? Does a distinction matter?
Oh, if this isn't the go-to trigger question of the Section 230 debate. Section 230 does not distinguish between platform and publisher. This is an artificial distinction that has taken hold in lay parlance as a way of, I think, actually out of a place of trying to have a legitimate discussion and trying to engage with people where these are often very specific legal concepts to understand. So I would rather not think about it as platform versus publisher, but think about it as, how do we treat libraries? How do we treat the bulletin boards in a coffee shop in an analog era? These are the argument for Section 230 is that Facebook is more like the library or like the coffee shop that happens to have a bulletin board or a meeting room than it is the New York Times, or than it is, Simon and Schuster sending out a book into the world. But when it comes to Section 230, this distinction is not actually there in the law.
Thank you. And Professor Citron, if you'd like to add anything.
I'm just giggling at the notion that it's like a trigger warning for all of us, right? As folks insist that, oh my gosh, you're not a neutral platform, as if it's a distinction with some difference, which it's not. So, we've seen a lot of myths around Section 230, which have made it more difficult to kind of clear the brush and say, all right, let's get rid of these myths and let's talk about really the stakes. And it's just unfortunately been confusing for lots of the folks in the public about what the stakes are. On the one hand, the stakes are, if we change if we introduce liability into the calculus, will we see the over filtering and over removal of speech, right? Which is a real thing to talk about, right? And how we go about sort of then gauging and re-gauging the liability question, I think, is why I'm trying to be as careful as I can be, recognizing that any liability does, in fact, we are going to have, there will be the risk of removing lots of speech, right? And some of that speech may be political dissent, the kind of speech we want to keep up, right? But there is also a part of the calculus that we're not thinking about, which are costs to speech and to livelihoods that right now Section 230 allows sites to host, make money off of, right, and do nothing about.
Thank you. And then Ms. Huddleston, if there's anything else you'd like to add to this question.
Well, first, I would just like to thank Professor Citron for acknowledging that one of the risks of introducing liability is that legitimate voices get silenced. And oftentimes, a lot of the debate, I think, are particularly the good parts of the Section 230 debate, the parts that we should be having, is this question of what is that appropriate balance? Because we can't deny that legitimate things will get taken down. I mentioned earlier, if you look at the DMCA and what's happened with copyright and how that's been abused to silence certain voices, even something that is the best intentioned law can go astray. And we can certainly, if time allows, talk about Sesta Fosta and some of the consequences we've seen there of sex trafficking is one of those things we generally all agree upon is bad. But we saw that Craigslist had to take down its personal section because it was overly concerned about the potential risk associated with liability as a result of this change in the law, therefore silencing completely legitimate speech in the process.
Thank you very much. And before we ask our last question from a panelist today, I'd just like to ask again if anyone in the audience does have any other questions that they would like either of our speakers to address, to please enter that into I believe it's called the general chat in the live stream, and hopefully we'll be able to access that soon. But without any questions from there, I'd like to move to Mr. Hennigan for his third question.
Thank you. Professor Citron, former Representative Steve King once suggested converting both social platforms and search engines into public utilities. Do you agree with former Representative King?
So that's in many ways sort of the same question about common carriers, right? Which is, I think it's a really important search engines, if they couldn't distinguish between content, what they do is prioritize content based on clicks, and there are like two pieces, right, that go into page rank. It's the amount of, clicking going on, but also the prominence of the page itself. And so, if they couldn't do that, it's unclear if we would have a search engine. Like if they couldn't make decisions, if they had to be a public utility of some sort, they couldn't distinguish or discern differences. I'm not sure there is a search engine, right? That's the premise behind, we're going to give you the best results is making decisions about the kinds of content that they're going to offer and proffer. So I think it's a terrible idea. And then when it comes to at the edge, or the content layer, that is sites like Twitter and Facebook, Blogger, anything, anyone, small, large, whatever. Again, like if you have to say all comers, you're going to have probably a site filled with nudity and hate speech. So I don't want to be there either. So I suppose my answer is, the kind of some of these metaphors, some of these analogies, like this is like, a common carrier, or this is like a utility, right? Like telephone, got to carry it, right? Like can't be listening in. I mean, in some respects, like it belies the function of a telephone, which is to be the dumb, the dumb wires. And of course, it's not all necessarily wired now, but like to be the dumb provider and say like, okay, and we can't listen in. In fact, that's what privacy laws are all about, for communications privacy, right? Whereas for search engines, like their entire thing is we're going to be looking at and making decisions and discriminating, right? And evaluating to show you what's most important, right? And so it is like, it's just a strange fit. It's definitely the wrong analogy, I think, that former Congressman King, I think I'm not sure if he's still in Congress, but you could tell me, but Representative King suggests.
Thank you. And then Ms. Huddleston, if you'd like to respond.
I think Professor Citron and I agree that these are not public utilities or common carriers, whichever term you want to use. They're very similar in terms of how it plays out. I do, though, want to use this time to expand a little bit on something I mentioned at the end of the common carrier question about, I think one of the things as we see this debate about are these public utilities or common carriers arise is the question of what does that do for innovation and what does that do for market competition? Because this would impose a lot of regulatory burdens on these companies, not to mention do away with some of the incentives to enter into this market in the first place. So oftentimes these comments come from people that are very critical of today's large tech giants. But the regulations that they're proposing by changing them into common carriers or public utilities would make it harder for that next platform to enter because they're going to be subject to the regulatory burdens that are associated with that. Or as Professor Citron was mentioning, going to be creating a platform that doesn't really serve the market that's out there of what the platform would be filled with, would have so many disincentives to an audience that most innovators won't choose to pursue that. So if we think the idea of platforms that host online speech have a value, platforms that host user-generated content in some form add value to society, and that's something that we don't want to at least disincentivize, then I think we should be very cautious of going down this route that would result in very heavy-handed regulation.
Thank you. And then Professor Citron, if there's anything else you'd like to add on that question. Okay, no worries. With that said, I'd like to now move on to our audience questions. Fortunately, we were able to receive and I'm able to read some of them. So our first question is not addressed to either speaker, So whoever would like to answer first, just feel free to hop in. What do you think of the way that the Eurozone regulates big tech?
So Europe has traditionally had a very different approach to technology regulation in general. And I've certainly written before about some of the impact of that, in that is likely part of the reason why we see fewer companies, fewer startups, a different kind of technology culture in Europe. It's a much more regulatory approach in general. When it comes to the Eurozone, a lot of the debates have been around competition regulation recently, but there are some differences in the speech dynamics as well. And we certainly could fill a whole panel about why and how those emerge. There are some historical reasons why free speech and the concepts of speech online have been perceived very different. There's a very different approach, particularly to hate speech online when it comes to the Eurozone. And as a result, what we've seen is some of these laws that are targeting hate speech, while they may result in taking down harmful comments, are also resulting in that sort of over moderation concern, or taking down comments that, while maybe not in good taste, were not the type of harmful speech that was meant to be targeted by such laws. But again, that's a very different context where you don't have the First Amendment in play. Most of the, for example, hate speech regulations over in Europe would come under very harsh First Amendment scrutiny if just directly imported to the US.
And then Professor Citron, if there's anything else you'd like to add on this question.
Yeah, the European Commission has a memo of understanding with 4 sort of dominant platforms with regard to hate speech, which is defined as, speech that demeans and degrades a protected group or vulnerable group. And what it has, the part of the MOU is that Amazon, Microsoft, Google, so YouTube, and Facebook agreed to take down hate speech within 24 hours. And then there was some criticism that they weren't doing it fast enough. And that's had, and I've written a bit about this concept of censorship creep and compelled conformity, that because platforms have a sort of one size fits all terms of service, that what we may be seeing is sort of an impulse to comply with the European Commission's memo of understanding that is going to result in the taking down of, speech having to do with like political dissent. We're going to see a one-way ratchet to more takedowns than we would otherwise. And so it's certainly true that, they do have a totally different conception, and their version of Section 230 is more of like a notice and takedown regime. And so we do see sort of more takedowns, though in some respect, in some areas that may be quite a good thing, right? And in others, it's problematic, right? And I think where we've seen some problems is in and around hateful or demeaning speech.
Thank you. And then Ms. Huddleston, if there's anything else you'd like to add on that question. Okay. With that said, I'll move on to the next audience question. Thank you both for speaking today. Professor Citron, would it be feasible for websites to apply for Section 230 protections through a regulatory agency? In other words, could Section 230's legal shield exist as a type of insurance for websites who may not be able to successfully moderate their platforms due to a variety of factors? And then there's an example given of Twitter.
Okay, so let's just make sure I understand the question, which is, might we see a regulatory body step in and provide some sort of safe harbor if there's a showing of, as I would argue, reasonable content moderation practices in the face of clear illegality? And that's the direction that the UK has gone, or is going, with its online harms bill. And it's like their version of the FTC. Office of Communication is going to be setting sort of best practices and providing, my understanding is, like a swarm of a safe harbor if there's compliance with those best practices. One thing that I'm writing a new book on intimate privacy, and something that I'm writing about in the book is that, I argue for courts to be the party to make these calls about what's reasonable content moderation practices. And in the gaps between decisions, we'll see what I think is some innovation around reasonable content moderation practices. But if the FTC got enough funding, right, and we're seeing some interesting proposals for $1 billion, right, in this new package for the FTC and its privacy enforcement, if the FTC got enough money, I'd be down to saying we don't need the courts if we had enough money, right, behind the FTC's privacy and sort of more broadly content moderation practices, then, perhaps they could be setting the kinds of creating safe harbors and reasonable content moderation practices that would evolve and wouldn't get stuck in the sand, right? Which is the beauty of a reasonableness inquiry, is that it encourages development and keeping pace rather than saying like, oh, I got a checklist, I'm good now, right? And so I think it's an interesting question. And if we had enough funding for a regulator, which we don't right now, but if we did, then I would certainly be open to having them be calling the shots about what's reasonable content moderation practices.
Thank you. Ms. Huddleston, if you'd like to, is there anything you'd like to say to respond to that question?
Yes, I have several thoughts. I'll start with kind of the last point about, whether or not agencies have enough funding to do this kind of job. And I think that, some of this comes back to what do we view as the role of the regulator in this? Should the regulator largely be absent and only intervening when there's harm occurring, or should it be a more proactive regulator? We've certainly seen with the current FTC, there seems to be a desire for more proactive regulation. There's a lot of debate around various other topics such as data privacy about whether or not that's the right step. I would, though, point that while the analogy was made to the UK's Ofcom, the other place where my brain originally went with this idea was Josh Hawley's Senator Hawley's proposal to have the FTC approve content moderation terms to ensure that platforms were being neutral. I bring that up to point out that part of the issue is how would such a regulatory agency actually play out in identifying who was good enough to get Section 230 protection. What reasonable counts in a particular scenario, and depending on what side of the aisle you're on, I think it's important to consider if the other side was in power, are you comfortable with a regulatory agency having this potential intervention into online speech and into the ability of certain platforms to have or lose this protection? I think the other element there, though, also goes to how do you view the potential for regulatory capture? What is the interaction between large players who, again, have the political capital, have the literal capital to hire lobbyists or to hire experts that know how to go through an agency's process, versus smaller platforms who then may need to go through the same process, but not have the same resources to do it. At the same time, you also have the length of time that most regulatory processes take. So again, that puts smaller players behind existing players who have already had the advantage of developing under the existing Section 230 regime. And I think that that's another question that really has to be asked. Finally, to the kind of question about agency versus a reasonableness standard, I think it's important to talk a bit about the pacing problem. The fact that agencies and regulation and policy often move very slowly. So a new idea can come out, and it oftentimes an agency can't change its rules to adopt that new idea quickly enough to approve something. So something could be a much better way of doing content moderation, but if an agency is very stuck on a rigid standard, it might not be able to approve that, and then that company wouldn't necessarily have Section 230 protection. Now, there are other times where the inability of agencies to keep trace has allowed for some what Adam Thier calls evasive entrepreneurship, the ability of companies like Uber or like Elon Musk and Tesla to go forward without agency approval. But oftentimes this is a real problem. And I think it's something that we have to really consider what the trade-offs for that would be in the context of online speech and in response to the ability of a wide range of platforms to have this protection.
Thank you. And then Professor Citron, is there anything else you'd like to add? Okay. So I'd like to move to our final question from the audience. And this goes back to something that was briefly mentioned. Can you elaborate on the issues with SESTA/FOSTA? And this is, of course, for either speaker to start. If
I feel like this is always such a sad, depressing moment for me because I helped Senator Harris's office when our VP was the Senator, Jonathan Mayer, and I sort of worked on and talked to offices about if we were going to have a carve out, what it should look like. And I feel like how it ended up was exactly the opposite of what we suggested, right? And it's true that all the senators signed on, and the House, it was like, can't talk about sex trafficking. And particularly as to minors, and think folks aren't going to sign on. But the key problem with this carve out is it creates the moderator's dilemma. So what it does is create liability under criminal and civil provisions that sort of look like this, the law that we have in federal criminal law, which says if you knowingly facilitate sex trafficking, then you might be responsible criminally, and then for civil penalties, either for state laws that sound a lot like that, right? Or sort of federal laws with the same sort of pattern. The problem with knowing facilitation is, I'm going to, Ms. Huddleston said it really well before, which is when knowledge is the standard, you're going to hide your head in the sand, right? On the one hand, so you're not seen as knowing, right? Or you're going to take everything down. Right. And so I think if we had no Section 230, law would operate and knowing would not be the standard. It would depend on the type of liability. But here we're talking about a carve out that's premised on the knowing facilitation of sex trafficking. And so to avoid being understood as knowing that you facilitated sex trafficking, you're going to either take everything down or do everything you can to say, no, I didn't know anything. Right. And to me, what we've seen is, unfortunately, that was overreaction. We've seen the takedown of a lot of speech by sex workers who are trying to make a living in a way that's safe for themselves. And unfortunately, we've seen the over removal, moderator's dilemma, the over removal of sexual expression, and a lot of, I think, expression that's frankly safer for sex workers. And so it's been disappointing, to say the least.
Thank you. And then Ms. Huddleston, is there anything else you'd like to add or respond to with regards to this question?
Yes. So again, I think this is a great example of the difficulties in any potential Section 230 reforms, because sex trafficking is one of those things that we can pretty much universally agree is bad. Like, I don't know anyone who's out there supporting sex trafficking as a good use of the internet. I do think it's important to add to the SESTA/FOSTA story that a lot of this was around concerns about one particular website, Backpage.com, and that Backpage.com was actually taken down by federal law enforcement prior to SESTA/FOSTA being signed. So SESTA/FOSTA was being debated, but they were actually able to take the website down prior to that being signed because of the criminal law activities that were going on that website. Now, the other thing to note with FOSTA/SESTA is now that it's been in effect for a while, there's more conversation not only around the response of content moderation online, but did this give law enforcement a tool that they didn't have? And there hasn't been that growth in the ability to prosecute this horrible thing as a result of FOSTA/SESTA. The GAO's report that came out recently did not find a large growth in the ability to prosecute sex trafficking or a significant change there. The other thing, though, that FOSTA/SESTA did is it shifted the conversation around Section 230. And we've seen a lot more calls for carve-outs for a wide range of things, everything from terrorism and misinformation and opioids, to my personal favorite is the carve out for home rentals that was proposed around Section 230 that was going to create additional liability if your platform is carrying illegal home rentals. But with that in mind, we have to think about what happens if there are a bunch of carve outs to Section 230. And in some ways, that's actually even harder for a platform to deal with potentially than just a world without Section 230 would be, because now you aren't sure what standard is being held to each particular type of content. So to Professor Citron's comment, instead of resolving the moderator's dilemma, you basically recreate the moderator's dilemma and in some ways make it even worse, because you now have to examine every single piece of content for what potential category it falls under.
Thank you. And Professor Citron, is there anything else you'd like to add with regards to this question? Okay, thank you. Our guests will now proceed with closing statements. Ms. Huddleston and Professor Citron, you each have 5 minutes. Ms. Huddleston, you may begin with your closing remarks.
Thank you, and thank you for having me today. I certainly feel like this was an incredibly thoughtful discussion, and a discussion that needs to be had more on this topic. Because oftentimes these days, Section 230 has become a very inflammatory term. It's the type of word or term that gets thrown around on cable news and that everyone feels they have an opinion on it without necessarily really examining what is underlying it. As I mentioned at the beginning, I think there are a couple of key things we need to take away as we consider what the future of online speech and the future of Section 230 debate looks like. The first of which is not to focus on any particular platform, that this doesn't need to be a debate over Facebook's decision or Twitter's decision or TikTok's decision. Rather, it needs to be a debate over whether we feel that private actors that carry user-generated content have the ability to and the correct incentives to make decisions around what content to carry, or if there's a need for further government intervention. Second, we need to also ask the question of what does this mean for the First Amendment? Not in terms of the users whose speech may be being taken down, but also what does it mean if we do allow government intervention into the decisions of private actors about what content to carry or to take down? What does that mean in terms of other areas of jurisprudence around the decisions we allow private actors to make with their rights of freedom of association as well as freedom of speech? And what would that mean for all of our experience online? And then finally, I think it's important to think not only about how this impacts our own experience, but also to look broader at the free speech online debate as a whole and look at what's going on in other countries before we're quick to throw around terms like censorship or that rights are being violated. When we see the ways speech has been attacked in other places, I think it makes many of us reflect on how fortunate we are to have the platform of the internet and to have a free and open internet where we can trust that if we have something to say, our voice is likely to be heard. And so with that in mind, I think we really need to take a step back from some of the more inflammatory rhetoric and have a deeper conversation about what the impact of potential changes could be before moving forward with any of those decisions.
Thank you. Now, Professor Citron.
So it's definitely gratifying to be having a sort of sober, calm conversation about how we might, and informed, so thank you, Ms. Huddleston, about how we might think about proposals to change Section 230, the benefits and the problems, right, of doing anything, changing what we have. When I suggested that I wrote an article called Cyber Civil Rights in 2008, and the notion that we had a problem with cyberstalking, that we should bring law to bear, and that we had a civil rights problem on our hands, that the speech of the marginalized was being pushed aside, silenced, and shut down. I was called pretty crazy, right? That we should do anything. And so having a conversation in which taking the notion of cyberstalking seriously, taking the notion of intimate privacy violation seriously, and the possibility that we might change Section 230 is certainly gratifying. I think what I would sort of two pleas. One is that we remember whose voices are potentially being lost in the universe with Section 230 as it is. Like if we do nothing today, there sites like Omegle, which is basically like a site for predators of children, sites like AnonIB, which is a revenge porn site, and other kinds of sites, they're going to live on, and they're going to torment people, young, right? They're going to torment children and women and minorities. So we're going to lose those voices and life opportunities. So I don't want us to forget them, that the stakes include them and their voices. And the second is, like any rational conversation, I think about Section 230 has to be a conversation as well as about privacy and the need for privacy legislation. The incentives right now is we have an advertising business model, which is the more collection of our intimate information, the better, to manipulate, to monetize our reading habits, our thoughts, our intimate life. And in doing so, I think we lose a whole lot. And if the business model is likes, clicks, and shares, then we're going to get a whole lot of what's probably pretty bad for us, right? And so, I think any conversation about 230 also has to be a conversation about the need for robust privacy legislation in the United States. So thank you. And thanks for having us.
Thank you, Professor Citron. Thank you also, Ms. Huddleston. I would now like to invite Mr. Pascal to deliver his closing remarks.
Ladies and gentlemen, every member of the Society for Constitutional Policy sincerely appreciates Professor Citron and Ms. Huddleston's thought-provoking participation in this critical fight for free speech online. We give special thanks to the Office of the President and the Provost of the University for their support, as well as Case Western Reserve University Office of Government Relations. A number of people and organizations helped make this possible today. We would also like to give special thanks to the Department of Political Science, the Center for Policy Studies, the student panelists and moderator, and our faculty advisors, Dr. William Dahl, Professor Andrew Lucker, Professor Laura Tartikoff, and Dr. Joseph White. Thank you again for joining us on the 234th anniversary of the Constitution.